All right, let's proceed. Yes, sir.
Thank you, Your Honor. May it please this honorable court, Jordan Shapiro for the appellant, Frank Schifano. What we're hoping for in this case is that you conclude that Mr. Razzaboni has only proven that Mr. Schifano had access to funds of his mother and his wife, but that Razzaboni failed, unlike the Birchall case, to file a proceedings under Section 19 of 224 to prove fraud or ownership of the funds, and that therefore we ask that this case be dismissed because of the inability to prove present non-exempt funds belonging to this defendant. Like the Birchall case, they claim fraud, but they did not present any evidence of present assets owned by him. What they did is they provided to Judge Cremens a huge stack of checks that were drawn on my client's mother's and wife's accounts from 2001 until 2008. They provided nothing to show any assets that are presently in his name or in his control after 2008. They spent from pages, half of their brief was all spent in proving that up until 2008, my client truthfully, and I agree, was doing fraudulent hiding, concealing, all of those things while he was working. The important distinction between the Birchall cases, very important, and I didn't point out in my brief, is that the law changed in 2010, perhaps as a result of the Birchall, but I'm not sure. Then they added a new sentence 2 of Chapter 224, Section 16, that said the case shall be dismissed, supplementary process shall be dismissed if the debtor is 60 years old and he has non-exempt income. Has exempt income. And in this case, the judge realized my client is 60, now he's 64. He's been collecting Social Security, lives on $737 a month. But I do want to point out the reason he's not in jail, as was a concern to Judge Gantz when he acted as the single justice, is that my client has been paying since September 5th of 2012, $100 a week out of his Social Security to this defendant, to this plaintiff, and that's why he's not in jail. But certainly there are reasons that we believe this court should be exercising its superintendence. Certainly this is an unusual case in that it's 18 years old. We think that although I know that the counsel in Birchall said he had the oldest case, I think we are the oldest supplementary process case pending in Massachusetts. My fellow had been ordered to jail in 2 weeks if he didn't pay $36,200. 2 weeks he was given to pay that kind of money. The evidence is clear that all the funds were his mother's and his wife's, nothing owned by him at all.
He was writing checks on them all.
He was writing checks on them, and so his parents, his mother, and the affidavits are clear that
the money?
And he was using the money for his family and his wife and his mother, and that's true. But again, we don't have the Section 19 of 224 where there's an opportunity for my fellow to disprove that there's any fraud. The mother and the wife didn't testify in this case, although they gave documents that they were. But the issue was, again, even those funds were 2001 to 2008. He's taken depositions. You saw that we stopped him from taking 18 more depositions that he sent out that the Superior Court denied him the right to do. And it was only through 2008 that they proved there was funds that my client had. They've deposed him, his wife, his mother. They've taken written discovery, all of those things. There is no money anymore. I agree. He was a bad boy when he was working from 2001 to 2008. That doesn't mean he still has assets. That doesn't mean that you're going to ignore 224.16. And by the way, I had a typo in my brief. I just noticed it this morning, but I referred to 2018 on page 9 and 15 when it should have been the 224. Section 16 that says the new amendment post the Birchall case in 2010 that says the case shall be dismissed if he's over 60 and has no non-exempt funds. And we also think that there's a different kind of fraud here than was in the Birchall case. The Birchall case, he had the money himself and he was hiding it in Switzerland and other places. My client has access, not his own. I agree with Judge Botsford that he was spending the money, but he has access, but he doesn't own it or control it. And the parents both say they gave him permission to do that, to go spend the money to buy his wife jewelry, to go on trips, vacations, all the things that they were doing that the parents allowed him to do. And so since then, there's been no discovery, nothing taken to prove any assets that he presently has availability to pay. Again, we say another important factor that was not the same in the Birchall case is this counsel has done a fantastic job of discovering every asset, every dollar, every dime, every lie, every cheat, every defrauding, every concealment that my fellow had, and presented it to Judge Cremens and proved that between 2001 and 2008, my client should have been making payments. We agree he should have been. If he asked him to make the payments, and you saw, he voluntarily discontinued the supplementary process in 2006, and my fellow's the uneducated carpenter and didn't make any payments that he could have been making. Now I'm stuck with a $36,000 bill because he woke up in 2012 and decided to pursue a supplementary process. Note that he didn't try to reach and apply the funds that are in the mother's and the wife's hands. Notice that he's just going after my client, which I think is a procedural flaw, in addition to the procedural flaw of not doing 224 Section 19. And so we think that it's very important that, the due process has to be protected, and we hope this court will get involved with the superintendents because my client should be free from bodily restraint. It's a protected liberty, due process under the Fourth and 15th Amendment, that he should not be incarcerated if he doesn't have present ability to make the payment. And again, I do concede that he's filed bankruptcy, he did fraudulent things in the past, but have they proven that he has a present ability to make payments today? And I believe, again, another concern that we had from the judge below was that there's no evidence on a weekly or monthly basis that my fellow has the ability to make payments. The court's supplementary process requires that the defendant have funds that are available on a weekly or monthly basis, that he has ability to make payments. And there's no evidence that the judge considered weekly or monthly ability to make payments from 2006 until today. It looks like she ordered him to make 360 payments, which goes back till about 2006, so far as I can tell, of $100 a week since 2006. But where is the proof that they introduced to her that on a weekly or monthly basis, my client had the ability to make weekly or monthly payments, as they typically do in supplementary process? They didn't do that, and as a result of that failure, we suggest respectively this case should be reversed and either remanded for further consideration as to whether there's been fraud here. There's no hearing on fraud. When we went to the hearings before Judge Cremens, it was purely present ability to pay. I didn't think I could lose because I didn't think he had proven. I knew what his documents were going to be. I didn't think he could prove any present ability to make a payment of anything, especially since all of his income is now Social Security. And I think that is all of the issues that I have for today, other than to point out that I was somewhat confused by Judge Gianza's decision where he said that the Birchall review was limited to the jail issues, but I think that the Birchall case really had much more than just the jail issues, and that we had the new, clear, and convincing standard that I think 4 of you were on the Birchall case panel. You established a clear and convincing standard, and you also made it very clear that the burden of proof is on the plaintiff throughout the entire case, and why Judge Gans thought that a 10% payment on $600,000 was a reasonable payment. I'm not sure what the result, why he did that conclusion, but we certainly disagreed with that, and that's why I appealed to the full bench, and hopefully you'll exercise your superintendence. Thank you for your attention.
Thank you, sir.
Good morning. May it please the court, Lawrence Murray representing the Razzabonis. I guess I find myself in the position again of defending the system, and I don't mean to sound facetious or in any way disrespectful, but I think if we accepted Mr. Shapiro's version or interpretation of this process, it would be made a mockery. And that's exactly what the O'Leary case talked about, which I think is dispositive of this case. It is absolutely true that his client committed numerous frauds over a number of years. And the length of time that was involved in this case, as this court is well aware now, I think, involved a thorough examination in bankruptcy court. Mr. Schifano had every opportunity to challenge the decision, the underlying judgment, default judgment, which he never did. He had every opportunity to challenge the findings of these courts. Two judges, I would point out, actually determined that Mr. Schifano had a present ability to pay and had an ability to pay and failed to do so. I can point, well, the record is replete, I think, with evidence of Mr. Schifano's access to money, and it's not just access. When I took his deposition during the process, and that took quite some time, he told me that he had absolutely no assets, no accounts, nothing, absolutely nothing. And when we found out through subsequent discovery that he, in fact, had not only had an account, but he wrote himself over $142,000 in checks during the period I had examined him, it was appalling. And I think that both Justice Carroll and Justice Cremens had more than an adequate record to determine that Mr. Schifano both had an ability to pay and refused to do so. The Birchall case standard, I think, was absolutely followed in this case. There's no question about that by both judges as well as the single justice of this court. I think the only point being made was that the Birchall case by the single justice involved someone who'd been in jail for 2 years, and that was the issue, whether that was still appropriate to do that. In this case, Justice Cremens, I thought, gave a well-reasoned, thorough decision based on an adequate record that was reviewed by a single justice of this court, and believed that payment of the arrearage, which in hindsight, on a $600,000 judgment, not having made a payment for over 9 years, $36,000 did not seem unreasonable to the judge. I would also point out, my brother overlooks the fact that one of the payments that he made was an $80,000 payment on a house, an investment property, that was sold at the end of 2011, as Justice Cremens notes, for a $64,000 profit. So there was certainly money that was available to pay this $36,000. The O'Leary case, I just wanted to point out to the court, because I think it is important. That's at 441-1018. We had a default judgment in that case. We had supplementary proceedings. We had an order to pay, found in contempt, and an appeal under 211-3. And the argument, just as here, was that it was excessive and contrary to law. This court, in affirming that decision by the single justice not to provide relief, noted that the opportunity to challenge the underlying default judgment was there, but he'd failed to do so, which is exactly what we have in this case. The court also emphasized that he had used every possible opportunity to delay or avoid the inevitable, and there was no reason to disturb the decision, particularly in light of the legislative apparent intent that there be no appeal from a decision in a supplementary process. Mr. Schifano had the additional benefit of 9 years of bankruptcy proceeding, in which the court ultimately determined that he was the least credible person that the court had ever seen in his entire career as both a judge and a lawyer. And for all those reasons, I think that the proper process was followed here. The due process argument that's made, notice and an opportunity to be heard, I think is replete in the record. And laches, as my brother's own treatise says on mass practice, shouldn't and doesn't apply in a situation to enforce the judgment. So unless there's any questions from the court, I would rest on the brief.
Thank you, Counsel.
Thank you very much.